I talked a little bit about what I view as the success of the Red Power movement, the fact that a lot of political change was brought about as a result of the activism during those years, the very sort of direct activism, sensational, sometimes dramatic, that got public attention and that brought public support. And public support translates usually into political support. So not only was the executive branch being more accommodating to Native American issues starting, starting in the 60s, but certainly in the 1970s, so were the other two branches, including Congress. We just looked at several laws that were passed in Congress that protected and in some cases reinstated and other cases recognized for the first time various rights of indigenous peoples. Between 1970 and 1985, the Supreme Court handed down 65 decisions connected to federal policy on American Indian law. And the vast majority of those were in the favor of the indigenous people. Now, that was the time of the Burger Court. There's Warren Burger. He was the Chief Justice from 1969 to 1986. Now, later on, in the late 80s and through the 90s, into the early 2000s, you had the Rehnquist Court, and the court became considerably more conservative, particularly where states' rights were concerned. The Warren Court actually had majority of people. I think it was 7-2, so far as justices who had been appointed by a Republican president. But that doesn't always necessarily mean what you think it's going to mean. It was actually, as was kind of par for the course for Republicans in the 1970s, there were a lot of moderate views and moderate approaches. With Rehnquist and several of the newer justices, especially Antonin Scalia. Antonin Scalia was really, really hardcore states' rights. And that is usually going to work against issues involving American Indians, right? Because the Constitution essentially guarantees that the federal government, specifically Congress, has the authority to deal with Indians, and that kind of cuts the state governments out. Frequently, in the late 80s and into the 90s, in cases that arose that dealt with sovereignty, the court sort of drifted farther away from the 1970s court. Now, in the 2000s, under the Roberts Court, it was pretty similar. There were some setbacks compared to the 1970s. A lot of times decisions would wind up being 5-4 against the interests of tribal sovereignty. But there's been recent development, I guess, in the last couple of years, when Scalia passed away and was eventually replaced by Neil Gorsuch, who is has a very conservative background, a very conservative sort of approach, but not when it comes to American Indian concerns, as his time on the bench before he was on the Supreme Court has shown. He has tended to side with American Indians on issues of sovereignty. So that has been helpful somewhat in the last few years, a time when they really needed what help they could get, as the political winds have changed yet again. All right, well, what I'm going to do next is take a look at some individuals that were from the Plains tribes in the era that we're now talking about, post-Red Power. Just a handful of individuals who have been significant on a national stage. Speaking of Congress, In 1986, this individual was elected to the House of Representatives, Ben Nighthorse Campbell, who is a Northern Cheyenne. 1992, he was elected to the Senate, where he served for many years and was chair of the Indian Affairs Committee. There he is on the right in his full traditional regalia. They're talking with President George W. Bush. After he left office in 2005, Campbell moved on to serve on the Northern Cheyenne Council of 44, which was the system, actually, the tribal council system of all the different bands and so forth that's been in place for a couple hundred years. As of 2020, he is still serving on that council. Next, we have John Echo Hawk and his cousin, Walter Echo Hawk, who are both Pawnee and who were both attorneys. In 1970, John Echo Hawk founded the Native American Rights Fund that was created to be sort of an American Indian version of the NAACP, a pro bono law firm devoted to Native American causes, particularly sovereignty. And over the years, half a century since then, both these guys have been very active. John Echo Hawk was actually on President Obama's transition team when he first took office. And Walter Echo Hawk has argued several prominent cases in front of the Supreme Court and has been instrumental in, among other things, the passage of the Native American Graves Protection and Repatriation Act. John Echo Hawk's younger brother, Larry Echo Hawk, has served as Attorney General of Idaho and was the Assistant Secretary of the Interior for Indian Affairs under President Obama. That, of course, is the position that for over a century was known as Commissioner of Indian Affairs. Next, we're going to look at Winona LaDuke, who is White Earth Ojibwe. In the mid-1980s, she was working as the principal at the high school on the White Earth Reservation. She has a master's in community economic development, by the way, and she was pretty young at that time, in her late 20s, early 30s, when she became an environmental activist. In 1989, she established the White Earth Land Recovery Project, which was designed to try to recover land on the reservation. Turns out that the tribe itself only controls a small percentage of the land within the boundaries of its reservation, in large part because of the Dawes Act, because land that had been appropriated and sold off or sold by members once they got their allotment. So this was an effort to raise money. It's a nonprofit thing to raise money to gradually buy back that land and to make it sustainable and to protect the environment on it, particularly to protect the timber on it. 1994, she co-founded with the rock band the Indigo Girls, organization called Honor the Earth. And in the 1990s, she was one of the foremost voices of the environmental movement. In fact, in 1996, and then again in the year 2000, she was the vice presidential candidate for the Green Party, presidential candidate being Ralph Nader. Since then, she has continued to be an environmental activist. She's written many books. She is working on establishing the growing of hemp at White Earth and on her own lands. As part of the White Earth Land Recovery Project, by the way, what she helped do was spearhead the reintroduction of cultivating and harvesting wild rice, which was long the major agricultural staple of the Ojibwe people. Finally, this picture I had to include just because that's the kind of guy I am, a name dropper. Talking about Winona LaDuke is a good segue, really, for the fact that, well, throughout the last 50 years or so, and most visibly within the last 10, 15 years, you will notice that whenever there is a major environmentalist movement, when there is a major protest, anything like that, you'll notice that Native American people are usually involved. They're usually front and center. Often they are even organizing the whole thing, even though there are a relatively small number of the American population. And you'll notice that Native American women often are in the very forefront, the very front and center, in efforts to protect Mother Earth, Inamaka, in Lakota. So let's look at some other strong Native women who have been involved in things like that lately. Next, we're going to look at the Dan sisters, who are Western Shoshone, not actually in the Great Plains, but plains adjacent. Shoshone, of course, we've mentioned several times over the course of this class. Anyway, there they are on the left in about 2003, 2004, and on the right, there they are in the late 1970s. Now, the issue at hand with the Dan sisters, who are activists and also ranchers, is a treaty signed in 1863 between the U.S. government and the Western Shoshone. It's called the Ruby Valley Treaty. And that treaty allowed white settlers access to Shoshone lands, not title or ownership. The lands were still part of the Shoshone Reservation, but white settlers were allowed to use it. Well, use it they did. Large numbers of them moved in and kept moving in, and eventually it was all segmented up, and it was considered, non-reservation land, even though by treaty it was reservation land. And the Shoshones, the Western Shoshone, tried to get legal action to maintain the tribal the treaty rights to the ownership of this land in Nevada is where it was, northern Nevada, I think. However, the Indian Claims Commission, remember them? That was kind of part and parcel with termination, even though that's not what they were planned and intended to be. The Indian Claims Commission in 1962 stated that the Shoshones had lost the right to that land by means of encroachment. In other words, it's not yours because someone took it away, and therefore that's the legal standing of it, which is, on its surface, kind of a ridiculous claim. So the Western Shoshone continued to press this issue, and starting in 1973, the Dan sisters began to press it themselves in a very active way. They had a large ranch with a lot of cattle and a lot of horses, and they started grazing their horses in particular, also some of their cattle, on the land that technically was part of the treaty land of the Western Shoshone, but which the U.S. government was claiming wasn't theirs anymore because there were white people on it. So the government started charging the sisters grazing fees for grazing their animals on quote unquote public lands, and those fees accumulated and accumulated year by year. Sisters would not have paid, even if they had the money, out of principle, because the whole point was to press a claim for the tribe's rights to their own land that had been really reserved. These rights had not been ceded. The lands hadn't been ceded. The rights hadn't been given up in that treaty. And over the years, the government continued to press them and to take them to court and charge them. And then they started trying to take their livestock, particularly their horses. They started sending people out to round them up. They used helicopters to do that, and they chased the horses around, and many of the horses were injured. And what they were saying was that this was for the protection of the horses. And they took the horses that they found on that contested land and were going to resell them. Now, in 1992, when they first started doing this, the sisters' brother, Clifford Dan, actually in protest as they were coming to take the cattle, set fire to himself. And the police, I think it was state police, but they rushed over and knocked him down and beat the fire out. And then they arrested him for assaulting an officer, and he went to prison for it. Meanwhile, the sisters continued their resistance, ultimately in the early 2000s going to the United Nations and arguing their case before the United Nations. And the UN said that the sisters and the tribe were in the right. But, that doesn't matter too much to the U.S. government. Now, in 1979, the Indian Claims Commission, as one of its last acts, it ended at the end of the 1970s. The ICC, because they were continuing this argument that the land had been lost due to encroachment, decreed that they would pay the Shoshone people $26 million. And that money was deposited into the trust that the government administers for the tribe. Now, a vote was taken among the tribal members. 80% of the tribal members voted not to accept that money. And so the tribe did not accept the money, but it was still deposited in their account in trust. In 1985, the Supreme Court ruled because the money was deposited, everything was settled. And that was the end of the story, and that they had given away their rights, even though they did not agree to this money and did not accept the money, which is still in the bank collecting interest, much like that money the Supreme Court ruled in 1980 should go to the Lakotas for the Black Hills. Now, over the years, the dilemma of these sisters and of their tribe has attracted a lot of public attention. There's been a lot of protests, like I said, all the way up to the United Nations. Why is it that the U.S. government, starting back in the 1960s, would go to such lengths and twist things so much to be able to claim that the tribe had no hold on this land when the treaty was very explicit, implicit in the fact that they didn't give the land up? Why would they do that? And why would they continue to take this course? Why would they harass this family? Why would they take away their livestock that they own? Why would all this stuff happen over the last several decades? Well, turns out there's a large amount of gold on that land. Imagine that. Now we're going to talk about Gail Small, who is Northern Cheyenne, grew up on the Northern Cheyenne Reservation in Montana, where she lives today. She is a professor of Native American Studies at the University of Montana and an environmental activist, and she has a law degree. Now, before we talk about Gail Small, we need to talk a little bit about the situation there on that reservation. Now, hopefully you remember the story from earlier of the Northern Cheyenne Exodus when they escaped basically from Oklahoma and made their way back to their traditional homeland. Only about 300 of them finally making it and having finally a reservation established for them. Sounds weird, doesn't it? On their own traditional homeland there in Montana, not too far from the Crow Reservation. Well, turns out, to bring things into the late 20th and into the early 21st century, turns out that that area, part of the Powder River Basin, is the location of about 40% of the coal in the United States. So there are a lot of coal mines there in Wyoming, and coal became an issue in both those Montana reservations beginning in the 1960s. Now, in 1966, the Bureau of Indian Affairs, essentially administering things for the tribe, which was how they did things, made a deal with the Peabody Coal Company. Maybe you're familiar with them from the John Prine song. If you're not, look it up. The Peabody Coal Company that gave them exploration permits. Now, the people on the Cheyenne Reservation were promised that they would make a lot of money from any coal that was discovered. They didn't really understand, nor was it adequately explained to them, what that entailed. For one thing, most members of the tribe thought an exploration permit gave the coal company authorization to look around and see what's there, and many of them were curious. But the BIA actually gave them the authority to set up coal mines and power plants and so forth. Eventually, a large portion of the Cheyenne Reservation. And the Peabody Coal Company came in with the intention of strip mining the whole thing, which did not go over well with the Cheyenne people. Of course, they were promised that it would be reclaimed, that is to say, that once they strip mined it, they'd fix it all back. But I know this isn't environmental history class, but I hope you realize that doesn't really work that way. Anyway, the Cheyenne people were pretty upset. The tribal council was pretty upset as they were getting ready to start this strip mining operation in the 1970s, because that's not what they had really, from their point of view, signed on for. They felt like they had been misled. The BIA was supposed to have authorized a cultural study before doing such a thing, and they did not. There was also a limit on how much of the Cheyenne land could be opened for development by law, and this far exceeded that limit. So the Cheyenne people, the council and the majority of the people, wanted to negate those contracts they felt had been obtained fraudulently. Well, the BIA wasn't aligned with that idea at all, and certainly the coal company wasn't. So this led to about a decade of actions in the courts and so forth, and massive resistance to these coal mining efforts. Gail Small was actually quite young when this all started in 1966. In the late 70s, she dropped out of high school, actually, in order to spend more time trying to help with the negotiation teams. In fact, later on, she became a part of the official tribal negotiation team at the age of 21, making her the youngest person there. She did get her high school degree, obviously, and later a law degree, and etc. In 1980, the Cheyenne were able to get the support of Congress, and Congress passed an act allowing the Cheyenne to negate those coal mining contracts, and it was signed off on by President Carter. And from that time forward, the Cheyenne people have resisted any efforts to talk them into allowing coal mining on their land. Now, again, this is right next to the Crow Reservation, and we'll be talking about the Crow in just a little bit. They had a different idea about it. Anyway, so they got through that. In 1984, Gail Small established a nonprofit organization called Native Action, which has been instrumental in all kinds of advances on the reservation there. Helped to get the first public schools, the first bank, the first chamber of commerce on the reservation. And in her law practice, she represented various different tribes on some important cases, including the Supreme Court case, Ling versus the Northwest Indian Cemetery Association, which was an important case in the 1980s, allowing for the protection of sacred lands. Well, in recent years, at least in the 21st century, Dr. Smalls, Miss Smalls, has had more to do, because in the early 2000s, the Bush administration opened up public lands right along the border of the Cheyenne Reservation to natural gas exploration. And in the early 2000s, the company started extracting natural gas, methane, from the area, from coal beds. Now, the way that they do that is they inject a solution of salt water with a high-powered pump down into the coal seam underground where the methane gas is, and break that up, and then bubbling to the surface is water, that salt water they pumped in, that has now got gas mixed in with it, and that's how they get the gas. The question is, what's to be done with the water afterwards? Well, they just dump it. Now, there is a process in which they could re-inject that salt water back down into the methane mines, but it's expensive, and the companies don't want to do that. It's a lot cheaper just to dump the water. But it is salt water, heavily salinated, and it damages the soil and makes the soil unable to grow anything. So if allowed unabated, eventually that water becomes part of the water table. It's going to spread onto the reservation, and the land of the Cheyenne would become essentially a desert. So Gail Smalls has been leading the fight to try to stop that from continuing. On the other hand, the Crow tribe took the deal, and in 1974, the Absaloka mine on the Crow Reservation started operations. Now, during the Obama administration, there was a moratorium on any further coal mining being started on Indian land. However, with the advent of the Trump administration, that was rolled back. And on a visit to the Crow Reservation, on which they were escorted around and shown the mining operation, and took a nice horseback ride with some of the Crow leaders, Vice President Mike Pence and Secretary of the Interior Ryan Zinke had a nice photo op, and Vice President Pence told the Crow leaders that the U.S. government's war on coal was over, and essentially it looked like the Crow were going to be able to have a second mine open up. Now, that first mine, the dividends that it pays off to the Crow Nation gives a quarterly check of $225 to each member of the Crow Nation. So they were hoping to get a second mine operational, and something a little bit well, something apprehension causing for anyone who's familiar with Native history and American Indian law came when the Secretary of the Interior, Zinke, made an offhand comment during that trip to the Crow Reservation about the trust situation between the United States and Native nations. And by the trust situation, I don't mean, hey, do we trust each other? I'm talking about Native lands being held in trust by the U.S. government with certain obligations and reciprocal situations being sort of required. Zinke said, is this going to go on indefinitely? He hopes that there is an off-ramp from that relationship. So anyone who has followed these lectures or knows about Native history will recognize immediately just how much that sounds potentially like termination, and how that could lead potentially to the opening up and privatizing of public lands, but also of tribal lands. However, there was a bit of a roadblock in that the Northern Cheyenne tribe sued the U.S. government for having rolled back that moratorium on coal mining on public lands. And so that is now stopped up in the court system. The Cheyenne, they don't want coal mines on their reservation, but they also don't want coal mines right outside their reservation because the pollution from them would affect them whether they've got the coal being extracted or not. This complicated things for the Crow and has led to some heightened tension between the Northern Cheyenne and Crow nations. And if you will recall, they didn't get along that well, all that great to start with.